I believe the next motion is CLF's motion for the board to take administrative notice of Inventor G's PUC brief that was filed during the PUC's advisory hearings.
So there are 4 points on this to make, and Ms. Lucarelli is correct. This is CLF's motion to have the EFSB take administrative notice of Inventor G's post-hearing memorandum on the issue of need in the PUC docket 4609 that addressed the issue of need. So I have four points to make on this. First, Inventor G says on page 1 of its response, quote, "It would be inappropriate for the board to take administrative notice of Inventor G's PUC post-hearing memorandum because a legal brief filed during an advisory opinion process is not the type of material of which the board can or should take administrative notice." And then on page 2, Inventor G says that the EFSB can take administrative notice only of judicially cognizable facts, unquote. And I just want to be clear that CLF is not asking the EFSB to give any credence whatever to the arguments that Inventor G advanced to the PUC. The reason we're asking you to take administrative notice of the document is that we think the arguments are very, very wrong, and we want to cross-examine Inventor G's witnesses on the basis of those arguments. We're asking you only to take administrative notice of the fact that Inventor G advanced those unsound arguments. Take administrative notice of the fact that Inventor G's lawyers made those arguments to the PUC. Second, Inventor G says on page 4, at the top of page 4, if the board finds that such a pleading filed before the PUC meets the requirements of EFSB rules, and determines that it can take administrative notice of Inventor G's PUC post-hearing memorandum, Inventor G will not object. However, for the sake of completeness, Inventor G requests that the board should then take administrative notice of all post-hearing memoranda submitted by the parties that participated in the PUC docket. And on that matter, I think we have complete agreement. I discussed this with Mr. Blazer earlier today. Let all the post-hearing memoranda from the PUC come in. We have no objection to our memorandum or Inventor G's memorandum. So I think that indicates an agreement. The third thing I want to say is that I think that agreement is particularly appropriate in this case because Inventor G says, in its response to our motion, Inventor G says that it stands today by what it said to the PUC. On page 1, Inventor G says, and I quote, "Inventor G stands by the statements and arguments made in its PUC post-hearing memorandum." On page 4, Inventor G says, "Inventor G stands by the statements and arguments made in its post-hearing memorandum." In that context, it's appropriate for this board to take administrative notice of that document because Inventor G is telling you that they stand by those statements. There's one more point in Inventor G's response to our motion that needs to be addressed. And that appears on page 5 of Inventor G's response. The last sentence of that first long paragraph. Inventor G says, quote, "Following EFSB approval, ISO New England does not, and certainly would not, prohibit Inventor G from bidding into future forward capacity auctions," unquote. That statement is not true. Schedule 22 of the ISO tariff, which I have open in front of me, has two separate provisions regarding the interconnection of resources like Inventor G. A resource that does have a capacity supply obligation under Schedule 22 of the tariff gets interconnected under Section 3.2.1 entitled Capacity Network Resource Interconnection Service. That is only for resources that can sell both capacity and energy into the ISO market. There's a separate tariff provision, 3.2.2 of Schedule 22, that provides for interconnection of energy-only resources, those that do not have capacity supply obligations. On September 20th, when the ISO involuntarily discontinued Inventor G CSO on Turbine 1, Inventor G was perforce bumped from Section 3.2.1 capacity network resources to the next section, 3.2.2 network resource interconnection. Inventor G's statement, October 15th, a few days ago, that following EFSB approval, ISO does not and certainly would not prohibit Inventor G from bidding into future capacity auctions is wrong as stated, unless, if by that, Inventor G meant that it is allowed, like any other resource, to submit a new qualification package, a new qual package for FCA 15 or FCA 16 or some future auction. That, of course, is technically true. But by the same token, every generator in the world, Entergy, Nextera, NRG, Dominion, Calpine, anybody is free to submit a new qual package ab initio and bid into a future capacity auction. Inventor G is no different from every other generator in the world in that regard. I have no evidence that Inventor G knew that this statement in its brief was wrong, that they knew that there are different interconnection tariff provisions for a resource with a CSO versus a resource without a CSO. But if they didn't know that, that is a stunning lapse or error by a company that wants to build a power plant in New England under the ISO tariff. But again, I think we have agreement that all of the briefs from the PUC on the issue of need can come in. We have no objection to Inventor G's brief coming in, and we have no objection to Inventor G's suggestion that all the briefs come in and that the EFSB take administrative notice of that.
Thank you. The Town of Burrillville fully supports and joins in this motion. In fact, the Town of Burrillville would suggest that all of the filings in the PUC docket 4609 should be taken administrative notice of in this matter. With specific regard to the memorandum of law, that is a public record. It's posted on the PUC website in docket 4609. The fact that it was filed in 4609 and the arguments made therein constitute facts which this board can take administrative notice of. They are, in fact, judicially cognizable facts and allowed under both EFSB Rule 1.29C and Rhode Island General Laws 42-35-10, parens 4, which is part of the Administrative Procedures Act. Also under this board's Rule 1.29C and 42-35-10, parens 1, quote, the board shall not be bound by technical evidentiary rules and when necessary to ascertain facts not reasonably susceptible of proof under the rules. Evidence not otherwise admissible may be submitted unless precluded by statute if it is of a type commonly relied upon by reasonably prudent men and women in the conduct of their affairs." End quote. Taking administrative notice of this memorandum in docket 4609 is the same as taking administrative notice of the testimony of Seth Parker in docket 4609, which this board has already done. That's Administrative Notice Exhibit 4. Now, Inventor stated repeatedly in its response, as Mr. Elmer pointed out, that it, quote, stands by the statements and arguments made in its PUC post-hearing memorandum. It's on both pages 1 and page 4. It further stated that it, quote, fully supports the position statements provided in its PUC post-hearing memorandum, end quote, on page 6. And today, Mr. Blazer just moments ago stated that the Unit 1 termination, quote, is irrelevant to the issue of need, end quote. It appears now that Inventor G has had its Unit 1 CSO terminated subject to approval by FERC. Inventor G is now arguing that, quote, the absence of a CSO does not equate to absence of need, end quote. That's in their objection at page 4. Inventor G is also arguing that, quote, even without a CSO, CREC is still needed, quote, and that's their objection at page 2. Standing by the statements and arguments in the PUC memorandum, reaffirming them here in argument today, means that Inventor G has now reaffirmed all of the positions it took in the PUC memorandum about the meaning and importance of having or not having a CSO on the issues of both need for the plant and cost justification for the plant. The statements that have now been reaffirmed by Inventor G include the following statements from the PUC brief. Quote, the ISO has determined that CREC is needed to meet the reliability needs of the region by awarding a capacity supply obligation CSO in its recent competitive wholesale capacity auction, end quote. That's at page 1. Quote, the project is cost justified because a competitive wholesale market process awarding CREC a CSO has ensured, and future auctions will ensure, that the capacity prices and energy prices for CREC's electric generation are cost justified, end quote. That's at 1. Quote, the need for CREC is determined in the competitive market. ISO manages the competitive energy market. Omissions. The award of a CSO by itself is compelling evidence of need. That's at page 3. Quote, the fact that ISO awarded capacity commitments over the net installed capacity requirement target is an indicator that CREC is needed, end quote. It's at page 4. Quote, if CREC clears in future FCAs and is awarded CSOs, it will be needed, period. If CREC fails to get a CSO in the future, it will not be needed, end quote. That's at page 5. Quote, a capacity supply obligation is strong evidence of need, end quote, also at page 5. Quote, capacity and energy supplies are procured in the ISO-NE wholesale markets. The competitive power market determines whether CREC is cost justified. By clearing the auction and being awarded a CSO, by definition, CREC is cost justified, end quote. That's at page 7. Moreover, in presenting its case before the PUC regarding whether CREC is needed, Inventor G's expert witness Ryan Hardy argued as follows in his rebuttal testimony with regard to determining need. Quote, why is the forward capacity market the appropriate mechanism to determine the need for Clear River? Omissions. The forward capacity market is the competitive free market mechanism that determines need for new power generating units in ISO-NE, end quote. That's at 2. Quote, the forward capacity market is the free market mechanism that determines the need for new generating units in ISO-NE, end quote. That's at page 3 of Mr. Hardy's rebuttal. Quote, clearing an FCA determines that a facility is needed by ISO NE to maintain reliability for that delivery year, end quote, page 4 of Mr. Hardy's rebuttal. Quote, by clearing the auction, Clear River was determined by the free market to be needed, period. Moreover, ISO NE explicitly stated after FCA 10 that the new resources that cleared FCA 10 are needed, end quote. That's at page 5 of Mr. Hardy's rebuttal. Finally, quote, all cleared capacity in an FCA is needed by ISO NE. That's at page 6 of Mr. Hardy's rebuttal. As we sit here today, subject to final approval by FERC, Inventor has no CSO for either Unit 1 or Unit 2. Therefore, utilizing Inventor's own logic and arguments, if having a CSO from ISO means that CREC is both needed and cost justified, then having the CSO terminated by ISO for Unit 1 and getting disqualified from participating in the market for Unit 2 means that the competitive market run by ISO has determined that CREC is not needed, and there is no longer any evidence in the record from ISO's competitive market that CREC is cost justified. It bears repeating that as Seth Parker testified and Inventor reaffirmed in its PUC memorandum, quote, if CREC clears in future FCAs and is awarded CSOs, it will be needed. If CREC fails to get a CSO in the future, it will not be needed. The town therefore respectfully submits that this board should take administrative notice of Inventor's PUC memorandum, and in fact should take administrative notice of all the filings made in the PUC docket, and then weigh the statements made by Inventor and its witnesses in those filings against Inventor's current position on what having or not having a CSO in the context of the crucial issues of need and cost justification actually means. Thank you.
Well, again, with respect to the main point of this motion, council conferred in advance. Initially, it was myself and Mr. Elmer, and we agreed that it would be bilateral as we suggested in our response, and that all of the briefs would be submitted. Then in discussion with Mr. McElroy, he suggested we simply agree that you can take administrative notice of the entire PUC record, which we also all agreed with. I believe that is really the end of the discussion. We are in agreement that this board may take administrative notice of the entire PUC record. We welcome that. Again, as far as Mr. Elmer's additional statements, he really made two that are related to each other. We indicate that we can participate in future capacity auctions, forward capacity auctions. He first said it's not true. At the tail end of his statements, he then said, in fact, every generator in the world can bid into a future capacity auction, including Inventor G. I think all of the statements in between those two statements are irrelevant. They're statements of his opinion on the law. Again, we can address that at the appropriate time in this hearing. But again, as to the main point of this motion, whether or not you should take administrative notice of any part of the PUC record, the parties are in agreement, and I don't think any more comment is warranted.
Anything further?
I have nothing further on this.
The second was CLF's motion for the board to take administrative notice of Inventor G's brief in the PUC advisory opinion, docket 4609. We all heard the discussion, and that morphed from the brief to the entire record. So since there's no objection by Inventor G, I am going to rule that the board take administrative notice of everything in that docket, everything filed, as well as the evidence presented at that hearing, at the hearings. So CLF's motion, as modified with a suggestion that would be the entire docket, is approved.